In September, the President announced a wind down of the Deferred Action Against Childhood Arrival Program, DACA for short, with a 6-month extension. My office received preliminary data showing 2,021 individuals who had DACA status terminated for criminal and gang activity. We want to know who these criminals are, what kinds of crimes they're committing, and if they're with any gangs. Separately, General Sessions, you announced earlier this year DOJ's recommitment to criminal investigation enforcement. 50 more immigration judges were supposed to be added to the bench this year and 75 more next year. We need to know what steps DOJ's taken and what still needs to be done to reduce this immigration court backlogs. There's another issue that I want to address that came up in the news just yesterday. In June 2015, and again last week, I wrote to the Justice Department about Russia's acquisition of uranium-1, which was approved during the last administration. That transaction resulted in Russians owning 20% of America's uranium mining capacity. It turns out that during the transaction, the Justice Department had ongoing criminal investigation for bribery, extortion, money laundering into officials for the Russian company making the purchase. Russians involved in the conspiracy were reportedly coordinating with high-level officials, some close to Vladimir Putin. While all of this was going on, the Clinton Foundation reportedly received millions of dollars from interested parties in the transaction. Then Secretary Clinton's State Department was one of the agencies that gave a thumbs up to the takeover. Somehow, despite all this, the previous administration approved the transaction. In my letter, I asked the agencies involved in approving the transaction if they were aware of the criminal probe and the intelligence operation examining Russian activity. This committee has an obligation to get to the bottom of this issue. The committee is also waiting for responses to 11 oversight letters sent to the Justice Department on matters from which the Attorney General is not recused. There are more letters that haven't been answered. The letters date back to January 2016. I expect these letters will be answered, including, most importantly, those from the previous administration. I also want to ask you about the firing of former Director James Comey. It was an important moment for the Department of Justice and for this country. The American people have a right to know why he was fired, especially in the middle of so many high-profile issues going on, including the investigation into Russian interference in the 2016 election. So thank you, General Sessions, for being here and for your continued service to the country. Senator Feinstein.
Thanks very much, Mr. Chairman. Good morning, Mr. Attorney General. This is the first time you've appeared before this committee, and I want to say welcome. But as a former member, you know well the oversight authority that we hold. As I mentioned at your confirmation hearing, I've got a deep belief that of the independence of the Attorney General. Although we've had attorney generals who view their job as serving the president and as an extension of the White House, I do not believe that's the job of the Attorney General. For the Attorney General's master is the people and the law. Importantly, his job is to enforce federal law fairly and equally for all Americans, which is why I was surprised that in April you declared that the Justice Department, quote, is in a new area. This is the Trump era, end quote. I want for a moment to explore with a few issues what you mean by that. And let me begin with voting rights. During your confirmation hearing, you testified, and I quote, the aggressive enforcement of laws to ensure access to the ballot for every eligible voter without hindrance or discrimination, end quote, would be a, quote, special priority, end quote. I was really very pleased to hear that. However, this year, the Justice Department discarded its long-standing position on a Texas voter ID law. For nearly 6 years, the Department of Justice had argued that the Texas law was unconstitutional and intended to discriminate against minority voters, based on evidence that shows voter ID laws, quote, have a disproportionate effect on minorities. Despite this, just 2 weeks after you were confirmed, the department dropped its opposition to the Texas law. The department also changed its position on another key voting rights case, this one involving Ohio's purge of voters. Under Ohio's procedure, voters who hadn't cast a ballot in 6 years and failed to return a postcard were removed from state voting rolls. This process reportedly resulted in the removal of 40,000 voters in one county alone, Cuyahoga County, which covers Cleveland and its surrounding suburbs. Civil rights organizations challenged the process, arguing that the National Voter Registration Act forbids the state from removing individuals for failing to vote. In July 2016, the Justice Department told the court it opposed Ohio's purge, and in September 2016, the Sixth Circuit agreed that Ohio's process for removing voters from its rolls was illegal. This ruling cleared the way for thousands of Ohioans to cast ballots in the 2016 presidential election. However, that decision is being appealed to the Supreme Court, and now the Department of Justice is taking the side of removing voters from the rolls, even though the last election clearly demonstrated how this policy harms eligible voters. I'd now like to turn to LGBT rights. Throughout my career, I've worked to ensure LGBT Americans have equal rights and protections under the law. And it's important to me that we preserve these protections. And this committee should not tolerate efforts to undermine the progress that's been made. At your confirmation hearing, you testified, and I quote, "We must continue to move forward and never back. I will ensure the statutes protecting the LGBT community's civil rights and their safety are fully enforced," end quote. So I was very pleased to learn that the department is sending a top hate crimes lawyer to Iowa to assist with prosecution of the case of a transgender teenager murdered last year. According to the Times, this decision was personally initiated by you. However, I was also surprised and concerned to learn that this summer, the Justice Department switched its position on Title VII and is now arguing that the law does not protect LGBT workers. Then on October 5th, just 2 weeks ago, you issued a memorandum to all U.S. attorneys and agency heads, instructing them that the department must now take the position that Title VII does not protect transgender employees in all cases. In other words, it appears that your department is urging the courts to allow employers to discriminate against all LGBT workers across the country. I hope you'll clear that up in your testimony. There are other controversial policies being implemented at Justice. The president's travel ban, for example. Multiple federal courts found the Muslim ban unconstitutional, including another court in Hawaii just yesterday. These travel ban efforts are an affront to our nation's commitment to religious liberty. Yet the Justice Department staunchly defends the ban. On DACA, you recommended in September that the program be terminated. And I think we believe these young people have placed their trust in the government. They have come out of the shadows. They've provided all their information to authorities. They seek the opportunity to get right with the law. And I think most of us believe these dreamers embody the American spirit and have made positive contributions to the country, so we should stand by them. Finally, we will also want to hear about the firing of FBI Director James Comey. President Trump initially said he fired Director Comey based on your recommendation and that of Deputy Attorney General Rod Rosenstein. Within days, however, the president admitted to Lester Holt on NBC News that he actually fired Comey because of, quote, the Russia thing, end quote. It's also been reported that the day before he fired Director Comey, President Trump summoned his top advisors and told him that he had prepared a termination letter. It's important, I believe, to understand what role you had in this process, including conversations with the president and others in the White House. Last week, the Democratic members of this committee sent a letter making it clear we would be asking about Director Comey's firing at this hearing, and that we expected answers or the assertion of a valid claim of executive privilege by the president. In conclusion, Attorney General, your department, as you know, is incredibly important, and you are as well. Our country depends on a department that's independent, committed to protecting the rights and freedoms of all Americans, not just some. So we look forward to hearing from you on these and other important issues. I thank you, Mr. Chairman.
General Sessions, I'd like to swear you at this point. Do you affirm that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Yeah. Before you speak, I'd like to, we have a long session ahead of us here, probably with you. Because there are going to be a lot of questions. Since we did not get a copy of your opening remarks, I was wondering if it'd be possible for you to submit your longer remarks and maybe summarize so we get to questions sooner. But I'll defer to you, but that's my request. But whatever time you need, take it.
Thank you, Mr. Chairman. I appreciate the opportunity to be with all of you, Ranking Member Feinstein and distinguished members of the committee, former colleagues and friends. I appreciate this opportunity. It's an honor of a lifetime. You have to know for me to serve as Attorney General of the United States of America. You can understand and know that with my 15 years in that department and my 20 years in this committee with oversight of that department, I understand the august responsibilities I have and the duties that I have to undertake, and I'll do my best every day to be worthy of the trust you've placed in me. Every single day, the men and women of the Department of Justice work to protect our national security against terrorist threats, defend our civil rights, reduce violent crime, stop deadly drug dealers, and strengthen the rule of law. And so today, I'd like to share some thoughts about what we are doing, give you insight into the exciting activities that are ongoing. The Department of Justice is resolutely focused on dealing with the terrorism threats that we face. They are real. The military tells us they can expect not a reduction after ISIS is defeated, but maybe even an increase in attacks. The President's executive order is an important step to ensuring that we know who is coming into our country. It's a lawful, necessary, and order that we are proud to defend. And indeed, most may not know, the Supreme Court has already vacated one court's injunction against that order, and we're confident will prevail as time goes by in the Supreme Court. We know colleagues, that violent crime is rising after almost 30 years of decline. For 2 years in a row, we've seen the fastest overall increase in violent crime in 25 years. The homicide rate increased 20% in 2 years. That's in 2015, the increase was the greatest in 49 years. I believe it's a trend we must confront. The president understands this. In one of his first executive orders, he directed us in simple terms to reduce crime in America. We have heard that challenge, we embrace it, and we are setting about to do something about it. At the Department of Justice, we understand a key fact, and we all need to understand this. 85% of law enforcement officers in America are state and local. They are better trained and more professional than ever. It's a huge factor in the decline in crime, in my opinion, that we've seen previously. And we know crime in America will never be reduced without a partnership between federal and state officers. There's no doubt that federal, state, local, and tribal resources professionally applied and in accord with scientifically proven policies can positively impact the crime rate. If you look at our cities, as Mr. Chairman, you noted, New York has dedicated itself over decades to highly effective, proactive, community-based policing. They saw 334 homicides last year. Chicago, on the other hand, while only a third of the size of New York, logged more than twice as many murders. So our professionals in the department have been intensely studying how research-based, proven crime reduction techniques can reverse increases in crime. They produced, in my opinion, a brilliant set of initiatives. I was very pleased with their plan. Whatever the violent crime might be or have been in the next few years, it will be lower if these policies are followed. I can assure you of that. Our aim is not to see how many people can be incarcerated, but to focus on the most dangerous repeat offenders and actually reduce crime and violence in America. An effective crime reduction strategy also means starving criminal enterprises of their profits. The asset seizure and forfeiture program is one of the most effective tools Congress has provided. I know a number of you are concerned about the operation of that program. I hear your concerns. I have established an asset forfeiture accountability director to oversee the entirety of this forfeiture program and to ensure it operates in an accountable and responsible way and be able to report to you at any time you need information about it. This department is committed to protecting the civil and constitutional rights of all Americans and to prosecuting hate crime violence. Every American, regardless of race, religion, sex, or sexual orientation, must be safe from violence and criminality. We will not shy away from defending First Amendment rights. We stand ready to enforce federal law, to protect the right to speak and to assemble peacefully, and to defend the free exercise of religion. We're in the midst of the deadliest drug epidemic this country has ever seen. We've seen nothing like it. Higher availability of drugs, lower prices, increased purity, along with the deadly substance fentanyl, have resulted in climbing death tolls across this country. It was 52,000 last year died of overdoses, 64 in 15, and 64,000 died in 16. Many of these deaths resulted from opioid overdoses that began with prescription drug addiction and then moved to heroin and fentanyl. There can be no doubt, colleagues, we need much stricter accountability in the manufacture and the prescribing and the distribution of addicted opioids. We do not need to delay this any longer. It does often lead to death through other drugs. We know that most of the heroin, cocaine, methamphetamine, and fentanyl that is fueling the drug crisis was brought across our southern border by powerful drug cartels, bringing violence, addiction, and death. An important factor in our long-term success requires securing our borders. For decades, the American people have asked for a just, lawful system of immigration. They are right in their demands. We can end the illegality. President Trump has sent an unambiguous message to the world, and the illegal flow has been reduced by almost by half. But there is more to do. We can end the lawlessness. Legislation is essential. The President has set out a reasonable and effective plan with numerous immigration priorities for this body to consider, including a border wall, significant asylum reform, swift border returns, and enhanced interior enforcement. With the progress already achieved, our country is on its way. And whether it's an end to sanctuary city policies or an e-verification system to ensure lawful employment, they are supported by the vast majority of Americans. There has been, I'm afraid, an erosion in the respect for the rule of law. Too often, advancing political agendas has been substituted for following the law. This Department of Justice respects Congress and the Constitution, and we intend to enforce the laws as you've written them. The DACA policy produced by the last administration could not be sustained. It was unlawful and contrary to the laws passed by this institution. And Congress, you now have the ability to act on this issue. I would just note the President has said he wants to work with Congress. He has a heart for young people. But we have got to have more than just an amnesty, friends. We need a good improvement in the illegality that's going on, and there is an opportunity right now. I'm telling you, an opportunity now to do something historic. So the department is also directing taxpayers' dollars to the overwhelming number of cities and states that cooperate with federal enforcement, but grant funding is not an entitlement. It's an allocation of taxpayers' dollars by the department to advance the goals set by Congress and the Department of Justice. So we urge our jurisdictions to cooperate with federal officials, stop letting criminal aliens back on their streets that further victimize your communities. It does not make sense. We are grateful that overwhelmingly most cities and jurisdictions cooperate fully, and to those who've heard our message and are now cooperating. So after 20 years in this body, I understand the responsiveness, Mr. Chairman, something you have been vocal about ever since I've been on this committee, and we're going to do so. We inherited a very significant backlog of unanswered congressional inquiries, Chairman Grassley, dating back to 2015. And we have already reduced it by half. You can be sure we'll continue to reduce that backlog, and it will remain a priority of ours. Finally, I want to address the letter I received last week from the minority members of this committee. That letter demanded that I determine by today whether the President will invoke executive privilege about issues on which I may be asked about today. I have considered this request very respectfully. It's an important matter, but consistent with the longstanding policy and practice of the executive branch, I can neither assert executive privilege nor can I disclose today the content of my confidential conversations with the President. Under the administration of both parties, it is well established that a president is entitled to have private, confidential communications with his cabinet officials, his Secretary of State, his Secretary of Defense, his Secretary of Treasury, and certainly his counsel and the Attorney General of the United States who provides counsel, and that such communications are within the core of executive privilege. Until such time as the President makes a decision with respect to this privilege, I cannot waive that privilege myself or otherwise compromise his ability to assert it. As a result, during today's hearing and under these circumstances today, I will not be able to discuss the content of my conversations with the President. I understand you have an important oversight responsibility today, and I hope you will respect this long-standing practice and respect the duty that I feel and that I face. Mr. Chairman, thank you, and I will be prepared to do my best to answer your questions.
I would like to make 2 points before I start to ask questions. Number one would be you, and only because you mentioned the backlog of letters. Remember that in January, the President put out an advisory that they would only answer questions for chairmen of committees. That leaves out about 35 Republicans. That leaves out 48 Democrats. I wrote to the White House. He's rewritten that advisory or whatever it was with the understanding that he would answer questions for any member of Congress, Republican or Democrat, chairman or not. The other thing is, for the benefit of the committees and the long oversight hearing we're going to have today, I thank you for your cooperation on a request I made last time, that if you get at the end of your 7 minutes and you start before the last second is hits and you ask a question, go ahead and ask that question. You go ahead and answer it, General Sessions, but don't have dialogue after the time's run out. Some of you noticed, I think, that there was special consideration given to Senator Leahy and Senator Hatch and Ranking Member Feinstein. I think they deserve that courtesy as former chairman of this committee and as ranking member. So if they run over a little bit, I hope just a little bit, then that's okay with me.
What's a little bit?
Let's vote on that.
Yeah.
The only one I paid much attention to was Mrs. Feinstein, and she was a couple minutes. So don't crow about that. You and Director Coates wrote a letter to the leadership about the importance of 702 FISA. You said that reauthorization of Section 702 is the department's top legislative priority. Question: if Section 702 were not reauthorized, can you tell us what impact that would have on the intelligence community and our national security interest?
Mr. Chairman, having been involved since I've been in the department with many of the day-to-day impacts of Section 702, I believe it would have a detrimental impact of significance. It would reduce our ability to identify terrorist acts and potential acts before they happen. That was one of the goals that we had when we passed the Patriot Act, and I know that I guess Senator Hatch and Senator Leahy worked very hard on that. It was one of the most intense times I've ever seen this committee do. 702 has proven its worth. Courts have upheld it. It has one of the most rigorous oversight procedures of any act, I think, in existence today. And it enables us to focus on terrorists abroad and to identify those who could be threats to us.
Now that we have that in place, the FBI, for example, is able to search limited 702 collections subject to minimization procedures using U.S. person data to help connect the dots. Question: if Congress were to impose a warrant requirement on assessing information obtained through so-called U.S. person queries, how would that affect the FBI's ability to do its job?
Mr. Chairman, it's just not practical, and it's not legally required, in my opinion, to have a warrant requirement for this information. It originates abroad by people who are not protected by the U.S. Constitution, and I do not believe that we could carry out the responsibilities that we're expected to do with a warrant requirement for any of the 702 type material.
There will be some talk of reforms in Congress, I'm sure. Are there any reforms that can be made that would help provide more transparency into the amount of information that the intelligence agencies collect or the amount of searches conducted, especially with respect to U.S. persons?
I think we're certainly open to discussing that with the members of this committee. A number of you have proposed ideas, and we would be pleased to provide our suggestions or support or concern as appropriate.
Yeah. I want to ask a question that looks like history, but it was in the news recently, yesterday, I believe. According to government documents and recent news reports, the Justice Department had an ongoing criminal investigation for bribery, extortion, and money laundering into officials for the Russian company making the purchase of uranium-1. That purchase was approved during the previous administration and resulted in the Russians owning 20% of America's uranium mining capacity. What are you doing to find out how the Russian takeover of the American uranium was allowed to occur despite criminal conduct by the Russian company that the Obama administration approved to make the purchase?
Mr. Chairman, we will hear your concerns. The Department of Justice will take such actions as is appropriate, I know. And I would offer that some people have gone to jail in that transaction already, but the article talks about other issues. So without confirming or denying the existence of any particular investigation, I would say I hear your concerns and they will be reviewed.
I think I know why you're probably reluctant to go into some detail on that, but I would like to remind you that Deputy Attorney Rosenstein directly supervised the criminal case when he was U.S. Attorney in Maryland. I don't think it would be proper for him to supervise a review of his own conduct, do you?
It would be his decision. He's a man of integrity and ability. If he feels that he has a inability to proceed with any investigation, it would be his responsibility to make that determination and should consult, as I told you I would, and as I have done with the senior ethics people at the department.
Reports suggest that the Clinton Foundation received millions of dollars from interested parties in the transaction. Bill Clinton received $500,000 for a speech in Moscow, June 2010, from the Russian government-aligned bank. The same month as the speech, Russia began the uranium acquisition process. This fact pattern raises serious concerns about improper political influence on the process by the previous by the Clintons during the Obama administration. Has the Justice Department fully investigated whether the Russians compromised the Obama administration's decisions to smooth the way for transactions? And if not, why not?
Mr. Chairman, we're working hard to maintain discipline in the department. It wouldn't be appropriate for me to comment on any ongoing investigation.
Okay, then let me move on to another issue. 2016, last year, well, I mean December last year, this committee published a majority staff report and criminal referrals regarding payments in connection with transferring human fetal tissue. The report and referral outlined evidence from the organization's own financial records that they profited from the sale of fetal tissue, which is in violation of law. No one from the department or the FBI replied to my criminal referrals or sought unredacted copies of the evidence outlined in the report. 7 months after the report and referral, there is no indication that anyone from the FBI or Justice Department has actually read the referrals and the full reports. I hope you will commit to providing the committee written confirmation when the relevant Justice Department FBI personnel have completed their review of both the referral and the majority staff report. That's my question, and that'll be the last one. I'll go to Senator Feinstein.
Thank you, Mr. Chairman. We will, I will evaluate your request personally and make sure it's promptly and properly handled.
Okay. Senator Feinstein.
Thanks very much, Mr. Chairman. I wanted to ask you a question or two about the firing of the FBI director. Specifically, I have your letter dated May 9th to the president. Specifically, what was your designated role in the decision to fire Director Comey?
It is, it's a matter that I can share some information about because the president himself has talked about it and revealed or that letter. He asked that Deputy Rosenstein and I make our recommendations in writing. We prepared those recommendations and submitted it to the president. Senator Feinstein, I don't think it's been fully understood the significance of the error that Mr. Comey made on the Clinton matter. For the first time I'm aware of in all of my experience, and I don't think I've heard of a situation in which a major case in which the Department of Justice prosecutors were involved in an investigation, that the investigative agency announces the closure of the investigation. And then a few weeks before this happened, he was testifying before the Congress, Mr. Comey was, and he said he thought he did the right thing and would do it again. So the Deputy Attorney General Rosenstein, who's got, 27 years in the Department of Justice, Harvard graduate, served for 8 years as U.S. Attorney under President Obama, and 4 years under President Bush. He said that was a usurpation of the position of the Department of Justice, the Attorney General's position, and that particularly we were concerned that he reaffirmed that he would do it again. So I think that was a basis that called for a fresh start at the FBI. Mr. Comey had many talents. There's no doubt about it. I have no hard feeling about that. But I am really excited about the new director, Chris Wray, who you've confirmed with an overwhelming vote. And I believe he's going to be able to do the job of FBI director with great skill and integrity.
What exactly did President Trump tell you was his reason for firing Director Comey? I know he has said he thought the department was a mess, and he asked you and Mr. Rosenstein to take a look at it. And my understanding was these two letters were presented, the letter from you dated May 9th and the letter from Rosenstein dated the same date, a response to that request to take a look at the department.
That's what I can tell you. He did ask for our written opinion, and we submitted that to him. It did not represent any change in either one of our opinion, as Deputy Rosenstein has also indicated, I believe. And we were asked to provide it, and we did.
Did the president ever mention to you his concern about lifting the cloud on the Russia investigation?
Senator Feinstein, that calls for a communication that I've had with the president, and I believe it remains confidential.
But you don't deny that there was a communication?
I do not confirm or deny the existence of any communication between the president that I consider to be confidential.
When did you first speak with the president about firing Director Comey? What date?
Senator Feinstein, I think that's also covered by my opening statement. I believe the president has the right and I have a duty to meet with him on proper occasions and provide such advice, legal or otherwise, as I'm called upon to do. I have done that, and I believe he has a right to protect that confidentiality until appropriate circumstances exist that he might choose to waive that privilege.
All right. Let me go to another aspect, and that's emoluments lawsuits. The president's facing 3 different lawsuits alleging he is violating the emoluments clause of the Constitution. In these cases, strangely to me at least, the Justice Department is defending the president. What did the department do to determine that it was appropriate to represent the president? Was the Office of Legal Counsel consulted?
I believe so. And I would say that it is the responsibility of the Department of Justice to defend the office of the presidency in carrying on its activities against charges that are not deemed meritorious.
And you believe that emollients is part of that charge? Emoluments?
Well, it's, you know, Senator Feinstein, I guess I'm not able to discuss legally all the case law and the history of it, except to say we believe that this is defensible, and we've taken the position that our top lawyers believe is justified.
Well, let me go to another subject, and that's the pardon of Sheriff Joe Arpaio. President Trump pardoned the former Maricopa County Sheriff, who was convicted of criminal contempt for defying a court order to stop racially profiling and detaining Latino motorists based solely on suspicion they were undocumented immigrants. The Washington Post reported that before he decided to pardon Arpaio, the president asked you to drop the criminal case against Arpaio. Did the president ask you whether the case against Arpaio could be dropped?
Senator Feinstein, I cannot comment on the private conversations I may have had with the president. I would just say that attorneys in the Department of Justice, at the request of the judge, prosecuted that case. A federal judge found the defendant guilty of a misdemeanor and for his actions, and the president decided to issue a pardon.
Well, let me ask you this. What was the process then by which the decision was made to pardon Arpaio?
I'm not aware of the details of it. To the extent to which I can provide you in writing, I would be pleased to do so. Well, but the president has the power to issue pardons with or without the Department of Justice involved, and that has been done in the past in some very dramatic type pardons. This pardon, I think, was well within the power of the president to do.
Well, my understanding is that pardon requests usually go through the Office of the Pardon Attorney in the Department of Justice, and decisions are made according to certain standards set out in that office's rules governing petitions for executive clemency. It has been reported that the process was not followed here, as you so indicate. So what you are saying, in fact, that there was no process, that the president simply made the decision to pardon Arpaio, who had been convicted.
I'm not intending to say that at all. I'm just saying to you that I am not personally at this moment not prepared to give you an accurate answer, because I don't know that I remember or know it precisely. Let me get you something in writing that would be accurate. I think I'd prefer to do that.
All right.
Are you done?
I'm over. I'm sorry. Thank you.
Senator Hatch.
Well, welcome back to the committee. We appreciate the service that you've given, and both on this committee and in your current position, as well as others. Before getting to my questions, I just want to set the record straight on something. Over the weekend, the Washington Post ran an article accusing Congress of passing a bill last year that the Post claims gutted DEA's enforcement authority. Now, the article insinuates that I, Senator Whitehouse, and the other bill sponsors put one over on Congress by sneaking through a bill that no one knew anything about. Now, Mr. Chairman and General Sessions, Ranking Member Feinstein, these allegations are complete baloney, and we all know it. This committee reported the bill out by voice vote. The full Senate agreed to the bill by unanimous consent. Every member of this committee supported the bill twice, first in committee and then on the floor. so I don't want to hear anyone claim they didn't know anything about the bill. The bill was 7 pages long. It took all of 5 minutes to read. If the Senate minority leader wants to take to the floor and decry this bill as unconscionable and as grounds for withdrawing the president's chosen nominee, he should remember that he himself supported the bill twice, once in committee when he was a member of this committee and again on the floor. We all supported this legislation, every one of us. We all voted for it twice. I've asked the Post to allow me to publish a response to their 10,000-word hit piece maligning me and my colleagues. I hope they'll do so, and I believe I deserve an opportunity to respond. Now, moving on, I have a few questions and would appreciate it, Mr. Attorney General, if you would keep your answers brief. First, I'd like to discuss a substance which is often offered as a substitute for opioids. Many states across the nation have adopted laws to legalize marijuana for medicinal use based on research suggesting there is some medicinal benefit or value to be found in it. To be clear, I remain opposed to the broad legalization of marijuana. However, I introduced, along with Senator Schatz, the Bipartisan Marijuana Effective Drug Studies Act of 2017, or the MEDS Act, because I believe that scientists need to study the potential benefits and dangers of marijuana. And I'm very concerned about recent reports that DOJ and DEA are at odds on marijuana research, particularly when it comes to granting applications to grow marijuana for further research. Can you clarify the position of the Justice Department regarding these applications?
I'd be pleased, Senator Hatch, and thank you for your leadership, and I've been honored to serve under your chairmanship. We have a marijuana research system working now, but there's one supplier of the marijuana for that research. People have asked that there be multiple sources of the marijuana for medicinal research, and have asked that it be approved. I believe there are now 26 applications for approval of suppliers who would provide marijuana for medicinal research. Each one of those has to be supervised by the DEA, and I have raised questions about how many, and let's be sure we're doing this in the right way, because it costs a lot of money to supervise these events. So I think it'd be healthy to have some more competition in the supply, but I'm sure we don't need 26 new suppliers.
Well, thank you. On another topic, I remain firmly convinced that we need to revisit original intent requirements in our law. Because of the lack of mens rea requirements in our laws, I believe that many Americans may be unwittingly breaking the law while not having the slightest idea that their behavior may be illegal. To address this problem, I recently introduced the Mens Rea Reform Act of 2017, which sets a default mens rea requirement unless a statute explicitly states that an offense is intended to be a strict liability offense. General Sessions, would you agree that mens rea reform needs to be a part of our conversation on criminal justice reform?
Well, it should be a part of our conversation. It has to be, and you've made sure that it is over a number of years. You've raised it and discussed it, and I've heard you articulate your concerns. So, yes, I think it should be a part of what we do, and we'd be pleased to work with you to evaluate what kind of legislation might be appropriate.
Well, thank you, and I with you. Just 2 weeks ago, you issued a memorandum detailing 20 principles of religious liberty, as well as guidance for executive departments and agencies in implementing those principles. The very first principle is, I think, the most important. Quote, "The freedom of religion is a fundamental right of paramount importance," unquote. And it, quote, "is not a mere policy preference to be traded against other policy preferences. It is a fundamental right." Now, General Sessions, would you say this status of religious liberty as a fundamental and paramount right imposes the same obligation on the legislative branch as it does on the executive branch?
I think it does. I would just say this, Senator Hatch, your legislation that you worked so hard and passed, Religious Freedom Restoration Act, was a big part of the foundation of the principles we set out in that religious freedom guidance that we produce at the request of the president. We believe that there is a lack of appreciation of the rights of Americans not only to have private religious thoughts, but to exercise their religious freedom. That's what the Constitution says. You should have a right to, Congress shall make no law to establish a religion nor prohibit the free exercise thereof. You have raised that in the past, and it was a big part of what we did. The legislation you and Congress passed was a big part of what we were able to do.
Well, thank you. I'd like to just make a couple of comments. First, a comment on the Supreme Court's recent decision to grant cert in the Microsoft Ireland case. Now, I know the department and I have different views on this case, and the topic remains controversial. That's why I introduced the International Communications Privacy Act, or ICPA, to create a clear framework for determining when law enforcement may access an individual's electronic communications, regardless of where those communications are stored. No matter which way the court rules, I believe this is a policy question that Congress needs to decide. Congress, not the court, should be the body that determines our data privacy laws. But I'm grateful to the department for its work thus far with me on ICPA, and I hope you'll continue working with me and others on this committee to refine the bill so it can be enacted into law. I know my time has run, Mr. Chairman. I appreciate that time.
Senator Leahy.
Well, thank you, Mr. Chairman, and welcome, Attorney General. And
Thank you, Senator Leahy.
I look forward to you also coming to the Appropriations Committee to talk about your budget. When you appeared before the committee in January, after your testimony, I was concerned about it, and I asked you in writing whether you'd been in contact with anyone connected to the Russian government about the 2016 election. You answered emphatically no. We later learned about several meetings between you and Russian Ambassador Kislyak. We didn't hear this from you, we got it from the press. During the height of the 2016 campaign, you reportedly met with Kislyak at a Trump campaign event on foreign policy, at a Republican National Convention event, and in your Senate office, all while serving as chairman of the then candidate Trump's national security team. Now, I've never accused you of colluding with Russians, but you clearly, in your answer of no, you concealed your own contact with Russian officials at a time when such contacts were of great interest to the committee. So now, one thing I do know, we've known each other for decades. We've worked together on many issues. If Senator Jeff Sessions was in my shoes and he asked the questions, he wouldn't tolerate being misled. So do you understand why members of this committee believe your answer no was false testimony?
Mr. Chairman, I appreciate the opportunity to talk about that. I believe my answer was correct. I have the question you asked. You started off in the preamble, by the way, was that said the intelligence community has concluded that Russia intervened in the 2016 election in an effort to help elect Donald Trump. The report is available. Russian interference in our elections is larger than any candidate or political party. It's about protecting our democracy, and I agree with that. And then you ask a series of subparts, A, B, C, D.
The question I'm referring to is I asked you if you'd had any contact with the Russians, and you answered emphatically no.
Well, I just wanted to say that the entire context of all your questions dealt with interference in the campaign by the Russian officials.
Specifically, did you meet with any Russians?
And so the question you're referring to is subparagraph E. and it says, several of President-elect's nominees or senior advisors have Russian ties. Have you been in contact with anyone connected to any part of the Russian government about the 2016 election, either before or after Election Day? And I took that to mean as not any casual conversation, but did I participate with Russians about the 2016 election, that something was wrong? Every one of your previous questions talk about improper involvement, and I felt the answer was no.
Okay,
and I answered no, and I did not meet with them in any way about the election.
Then let me ask you about that, because later in March, when you did disclose such meetings, you said you did not recall what was said at the meetings. Now, your answer to my question was an emphatic no. It wasn't, I don't recall. Now, you're a lawyer. I'm a lawyer. You're, in fact, our nation's top lawyer. Is there a difference between responding no and I do not recall?
Well,
is that legally significant?
Yes, but
thank you.
Certainly it is, Senator Leahy.
So that if you could not recall, then you could not have answered my question, my first question, yes or no, if later you said you don't recall what was discussed. Now, the reason I asked that, U.S. intelligence intercepts reported in July appear to reveal that you did, in fact, discuss campaign issues with the Russian ambassador, including candidate Trump's position on Russian-related issues. So let me ask you this. Since the 2016 campaign, have you discussed with any Russian-connected official any of the following: emails, Russian interference, sanctions like the Magnitsky Act, the so-called adoption issue, or any policies or positions of the campaign or Trump presidency? This is since the 2016 campaign.
Senator Leahy, I want to be accurate, so I don't want to have any ambiguity about your questions, but that's a lot of questions. So let's think about this. I have never had a meeting with any Russian officials to discuss any kind of coordinating campaign efforts. I know you're shaking your head, so I want to first say.
Let's take it separate piece by piece.
All right.
Discuss any of the following: emails.
Repeat the question again about email.
Since the 2016 campaign, have you discussed with any Russian-connected official anything about emails?
Discuss with them. I don't recall having done any such thing.
Have you discussed with them Russian interference in our elections?
No.
Have you discussed anything like sanctions like the Magnitsky Act, what they call the adoption issue?
I don't believe I've ever had any discussion at any time about the Magnitsky Act.
Have you discussed with them any policies or positions of the campaign or Trump presidency?
I'm not sure about that. If I met with the Russian ambassador after I gave a speech at the Republican convention, he was right in front of the speakerphone, and we had we had an encounter there. And that he asked for an appointment in my office later. I met with 26 ambassadors in the last year, and he was one of them. He came into my office with two of my senior defense specialists and met with me for a while, and I don't recall any conversation about, what was this last subject? Let me get it right. You asked me.
I think he wants you to repeat something.
Yeah.
Any policies or positions of the campaign or Trump presidency?
I don't think there was any discussion about the details of the campaign, other than it could have been that in that meeting in my office or at the convention that some comment was made about what Trump's positions were. I think that's possible.
Were you requested, have you been interviewed, or have you been requested to be interviewed by the special counsel, either in connection with Director Comey's firing, the Russian investigation, or your own contact with Russian officials?
You'll have to ask the special counsel.
No, I'm asking you.
Repeat the question then.
Have you been interviewed or been requested to be interviewed by the special counsel, either in connection with Director Comey's firing, the Russian investigation, or your own contact with Russian officials?
Well, I'd be pleased to answer that. I'm not sure I should without clearing that with a special counsel. What do you think?
I'm just saying, have you been interviewed by them?
No.
You haven't been interviewed by the special counsel in any way, shape, or manner?
The answer is no.
Thank you. Okay, Mr. Chairman, I've gone over my time. I appreciate the courtesy, but I do have a lot more questions along this line.
Senator Lee.
Thank you, Mr. Chairman. Thank you, Attorney General Attorney General Sessions, for your service and for being here today. In May, you implemented a new charging policy for federal prosecutors. The policy requires, as I understand it, that prosecutors must be required to, quote, pursue the most serious, readily provable offense. The policy does permit prosecutors in some circumstances to apply for approval to charge something less than the most serious offense that is readily provable. Can you tell me, Attorney General Sessions, what factors the department will be considering in deciding whether or not to grant approval to those prosecutors in those instances who want to charge something less than the most serious, readily provable offense?
Senator Lee, the decision, that memo's decision, establishes the long-held position of the Department of Justice that a prosecutor should charge the most readily provable, serious, readily provable offense. It was altered by the previous Obama Department of Justice, I believe, Attorney General Holder, in which he declared that you should not, and even directed you should not, charge what Congress has set as a serious offense that carries a minimum sentence.
So you were restoring what was previously known, I think, as the Ashcroft policy?
Restoring what was previously set. And I was determined to have a simple directive to our capable assistant United States attorneys, not have a long 6-page memorandum. We submit a 1-page, slightly over 1-page memo to them, and it said, if you think that's not just, and you clear it with your U.S. attorney or the designee of the U.S. attorney, you can charge less than the most serious, readily approvable offense. Don't have to call Washington. Don't have to get some bureaucracy. We're going to trust you. And I told them I hope that would work. If we had serious problems with it, we would revisit it.
Okay. Do you?
And by the way, it only requires that the minimum sentence be imposed. Minimum mandatory. It doesn't require the maximum sentence, as some have said. It simply says that if you commit a serious crime that Congress says should carry a certain sentence, you shouldn't fail to charge that because you want to have a different sentencing result.
Do you track, or do you intend to keep track of how often attorneys, how often prosecutors, and which prosecutors in particular, are departing from this?
Yes, we will. I don't know that we have a formal process. Deputy Attorney General Rod Rosenstein is an experienced supervisor, 12 years of assistant United States attorneys. We've discussed this in depth, and we feel like that this is a sound policy for the Department of Justice and essentially restores us to what it used to be, but with perhaps even more flexibility than previous policies.
In March, Justice Thomas issued a statement in connection with the denial of certiorari by the Supreme Court in a case called Leonard versus Texas. In that statement, he suggested that modern civil asset forfeiture practices may be unconstitutional, at least cast some doubt on the constitutionality of those procedures as used by the federal government and many state governments. In May of this year, I wrote a letter to you asking whether the department would review its civil asset forfeiture policies and practices. In July, you announced some new policies that expanded the Department of Justice's use of civil asset forfeiture. Can you tell me whether you have asked the Office of Legal Counsel or any other component of the Department of Justice to provide a formal review of civil asset forfeiture practices of the federal government, of the states, and particularly the states and localities that participate in the equitable sharing program with the Department of Justice?
We had an intense series of discussions in the department about this subject. It's one that I'm familiar with, having served 12 years as United States Attorney myself and having utilized this policy. The policy was changed by the former Attorney General and constricted the ability of asset forfeiture in a number of ways. I simply restored the previous policy. The change only occurred 2 or 3 years ago. I believe it's the best policy, but I'm aware of the serious concerns you have and others have. I have constricted and placed some limits on how we do these forfeitures, and I have just announced the appointment of a special director of accountability to be in charge of all the forfeitures in the United States, to review them, to review any complaints that arise. We want to carry out this policy effectively and fairly without abusing anybody's rights. I would note that for decades it's been affirmed by the Supreme Court. I don't believe there are votes on the Supreme Court that would declare it somehow now not legal, and we want to do it right.
I'm not sure that's clear one way or another. I mean, I understand your position, but I think there is some lack of clarity on this, and I think the statement issued by Justice Thomas in connection with the denial of certiorari in Leonard versus Texas does cast some doubt on it. But one of my questions is, hey, have you asked the Office of Legal Counsel for an opinion on this?
We're simply restoring the law that's been in effect for decades, and I don't know that we've asked a formal opinion of the Office of Legal Counsel, and don't think it's necessary to do so.
Okay. As you know, the reason I'm concerned about this is because in our criminal justice system in the United States, we have robust protections for the accused. You're entitled to a jury trial, to court-appointed counsel. You have a lot of due process protections as someone accused in this country. If the courts can circumvent those rights, at least with respect to the property of an accused, or to the property of somebody who may not himself or herself even be accused of a crime, but just as to which there is some suspicion about the involvement in the property, that presents significant concerns. If the government can just seize the property and then make it the government's property rather than that of the owner, such that it reverses the presumption of innocence, it reverses the burden of proof, and eliminates the requirement that proof of a crime be proven beyond a reasonable doubt. That's a concern. It's especially a concern where some states and local governments have adopted legislation restricting the use of this, and it's been then circumvented with the help of the federal government through this equitable sharing program. I do believe it needs to be reviewed and reviewed aggressively. Thank you, Mr. Attorney General.
Briefly, Mr. Chairman, a number of years ago, almost maybe 10 years ago, Senator Schumer, when he was a member of this committee, and I reached an accord when these issues were being raised. We raised the burden of proof, so a seizure of assets, often cash, those seizures cannot be effected without probable cause to believe it's either a product of the drug or criminal activity or a facility used to facilitate a criminal activity. And then if the person who had the money contests the case, they would have to the government has to prove it on a preponderance of the evidence, which is a normal civil standard in a civil lawsuit. And the probable cause standard, you can arrest an individual, a grand jury returns indictments on probable cause. So it meets the same standard, really, that it would take to put somebody in jail. So I think it's a sound policy. 80% of the seizures are not even contested when DEA, the Drug Enforcement Administration, sets up a procedure for claimants to make their claim. And I believe it's a sound policy. But we'll continue to monitor it. I'm going to watch it even closer than we have before, and I would be pleased to stay in communication with you and hear your concerns.
Senator Durbin, and I'll return before Senator Durbin's done here. I'll be out just a minute. Go ahead, Senator Durbin.
Thank you very much, Mr. Chairman. Attorney General Sessions, welcome back to the committee. Your positions on immigration, DACA, Dreamers, well documented. We have all given many speeches on the floor of the Senate, yourself included, and I think your position in opposition to those programs has been well documented over the course of your Senate career. I would like,
but it may not be quite as simple as you might suggest.
I'll leave your rationale to
Okay.
you to explain, but I think
Yeah.
I know how you voted consistently against comprehensive immigration reform and any form of the DREAM Act. But let me ask you this. Last month, you announced the Trump administration was terminating the DACA program. It's my understanding that according to longstanding Justice Department policy, the Office of Legal Counsel is, quote, responsible for providing legal advice to the executive branch on all constitutional questions. OLC issued a 33-page memo on November 19th, 2014 that concludes that DACA is lawful, and it's a lawful exercise of executive authority. And when you go back to the Department of Justice after your hearing today, check your website. That opinion is still on your website, that DACA is lawful. So could you please tell me whether you consulted with the career attorneys at the Office of Legal Counsel before your announcement that terminated DACA?
We did. We talked with a large number of experienced lawyers in the department. Senator Durbin, what I would say to you, and I believe this is accurate, that the so-called approval of DACA by OLC, Office of Legal Counsel, was based on the caveat or the requirement that any action that's taken be done on an individual basis. The court it held that struck down DACA that individual decisions were not being made, and a blanket policy was in effect being carried out under the DACA program. In reality, that was not an individualized basis, and therefore that's why the court found it unlawful.
That statement is a departure from what is currently on Department of Justice website, the OLC opinion of 2014. If you have a new OLC opinion that was the basis for your letter to Acting Secretary Duke or your statement terminating DACA, will you provide us with a copy of that opinion?
Well, I would be glad to, but I think it is fair to say that the OLC document required and said a DACA program might be legal if it was done on an individualized basis, that the Department of Justice can't just wipe out whole sections of the American law and just say we're not going to enforce it after Congress has passed such a law. So I'd be glad to review it, and we'll review the validity of the whole.
I hope you will. And for the record, each DACA recipient is individually interviewed, goes through an individual criminal background check, and determines whether there is individual eligibility. So having said that, I would ask you one last thing.
The court found otherwise.
Well, I hope you'll share that OLC opinion. Did you have any communication with the Texas Attorney General or any other Attorney General who was threatening to bring a lawsuit to void DACA before the decision was made by the Trump administration?
I would just say this, Senator Durbin, that kind of legal discussions, I believe, would be part of the work product of the Attorney General's office, and I should not reveal it.
You cannot tell me, you're saying you are privileged, that communication is privileged, that you had a communication with the Texas Attorney General about their threatened lawsuit against DACA before the administration's announcement? You say that's privileged?
Well, even the OLC communications we have are, in fact, are privileged. So I would say that's correct. I'll review it. If it's something I can feel that it's appropriate for me to reveal to you, I will do so.
I think this would have been just about the moment when Senator Sessions of Alabama would have blown up if the Attorney General said he can't even tell us whether he communicated with another Attorney General in another state.
Well,
I take you to one part of your statement here that I take personally because I happen to represent the city of Chicago, and I'm honored to represent that city.
I know you are.
What happened in Las Vegas was tragic and awful and heartbreaking. 59 people killed, over 500 wounded by gunshots in just a brief period of time with some military-type weapon. It was just awful, horrific, and disgusting. Having said that, so far this year, 3,000 people have been injured by gunshot in the city of Chicago, and over 500 have been killed. This is not something that is a political debate in my heart. It breaks my heart to think what the families are going through in this city that I represent. The superintendent of police who's worked there, and you gave credit to local law enforcement. I'm glad you did. I join you in that. He's worked in that police department for 30 years. I want to read to you what he said. The federal government's plans, the terminating of burned grant funds, will hamper community policing and undermine the work our men and women have done to reduce shootings by 16% so far this year. And this is the sentence I want to focus on. If I've said it before, and I'll say it again. Undocumented immigrants are not driving violence in Chicago, and that's why I want our officers focused on community policing and not trying to be immigration police. The money we are going to get, we hope to get, from the federal government for burn grants, we're putting into a program called ShotSpotter. You probably know what that is, but it's a monitoring device in our city, block by block, that can tell instantaneously when a gun has been shot. And so our police can respond instantaneously to try to get the shooters and to save the life of the victim. You want to cut back these funds because you want the city of Chicago to play the role of immigration police on federal civil laws. Mr. Attorney General, you're not helping us solve the murder problem in the city of Chicago by taking away these federal funds. And the superintendent says that your pursuit of undocumented immigrants has little or nothing to do with gun violence in Chicago.
Well, Chicago is a great city. It's got many good things going for it. I do think this murder rate is a cloud over the city, and it looks like this year may be even higher murder rate than last year. Good community-based policing is absolutely essential for this. I'm worried about the health and morale of the Chicago Police Department. We'd like to see that improved. I think the politicians cannot say that if you remove a violent criminal from America that's illegally in the country and he's arrested by the Chicago police and put in the Chicago jail, that once they're released, they shouldn't be turned over to the federal ICE officers so they can be removed from the country. They were here illegally to begin with, much less commit another crime, and then should not be. How does that make the city of Chicago safer when you don't remove criminals who are illegally in the country?
You can't give an opening statement throwing a bouquet to local police and then ignore what the superintendent of police in Chicago tells you has nothing to do with gun violence. You want to cut off federal funds to that city and come here and criticize the murder rate.
I have increased the number of ATF agents to prosecute gun crimes in Chicago by 12, which is quite a large number, more than any other city, 12? I believe. Yes. And, well, we're not, the United States government can't take over law enforcement for the city of Chicago. We're not doing it for New York. We're not doing it for a lot of other places.
Nor can the city of Chicago
we have made
take over
a surge of ATF agents to Chicago, and we'll continue to work with you. I do not want to not have grants go to Chicago, but we need their support. When somebody's arrested in the jail that's due to be deported, we just simply ask that they call us so we can come by and pick them up if they need to be removed. That's not happening, and we've got to work through it some way.
Senator Kennedy.
Thank you, Mr. Chairman. General session. Thank you. Welcome back. Thank you for your service.
Thank you.
Did you conspire with Russia or an agent of the Russian government to influence the outcome of the 2016 presidential election?
No.
Do you want the special counsel who is investigating those matters to succeed?
I want him to complete his investigation professionally, yes.
If he asked you for your cooperation, would you give it?
Yes.
If he asked to meet with you to discuss what, if anything, you know about all that, would you agree to meet with him?
Absolutely.
I want to talk to you for a second about New Orleans. New Orleans is extraordinarily important to my state. My first job in government was with a governor, Governor Buddy Romer, and at the time he took an economic development trip to Japan. He tells a story he was meeting with about 20 Japanese business people. And he started off by asking them, he said, how many of you have been to Louisiana? He said, five Japanese business people raised their hand. Then he said, how many of you have been to New Orleans? He said, 15 raised their hand. It's a big part of our culture and our economy. We've got a crime problem in New Orleans, as you know. We had a police officer, Officer McNeil, killed in the line of duty this weekend. The burn grants are very important to New Orleans to help us fight crime. Now, your office wrote a letter to my friend Mayor Landrieu asking him questions about his or the city's compliance with 8 U.S.C. Section 1373. Let me cut to the chase. There have been allegations that New Orleans is a sanctuary city. You have asked for information. Mayor Landrieu, who again is my friend, but you've got to call him like you see him, wrote you back a very unprofessional letter. And I'm sorry for that. He called you caustic. He suggested you were just a mere politician. He said you were scapegoating immigrants. He called you a fear-mongerer. And he basically called you a liar. And I don't consider that to be productive discourse. So I apologize on behalf of Louisiana. Would you agree with me that we're a nation of immigrants?
Well, virtually the vast majority have immigrated here at one time or another, for sure.
But we're also a nation of laws. Is that correct?
That's correct.
Now, if I don't agree with the law, do I have to follow it?
Yes.
I hate traffic cameras. I don't agree with them. Do I have to follow the laws about traffic cameras?
Yes.
Now, if I don't like the laws about traffic cameras, I need to go change them. Is that right?
That's correct.
Okay. Would you be willing, would you make yourself available if I could arrange a meeting with you and your colleagues and Mayor Landrieu? We're about to elect a new mayor in New Orleans, to sit down and work with the Department of Justice to resolve these allegations of being a sanctuary city in a way that the Justice Department is comfortable with, so we can keep that money.
Absolutely, I would. And I would just say, Senator Kennedy, that there were 10 cities during the last Attorney General's tenure that were noted as being cities likely to be in violation of federal 1373 cooperative law that requires cooperation on detainers and or at least communications with federal law officers. New Orleans was one of those.
Yes, sir.
About half of those now have gotten off the list. Would love to see New Orleans get off the list, but we're not there yet. Yes. The mayor has talked openly about some of these strategies where he describes what we are asking them to do is to go out and arrest people in the city that are here illegally. We're not asking that. We're asking that when they the city arrests somebody that's illegally in the country for some other crime, to communicate with us, give us notice before they're going to be released back into the community, because we may find, our ICE officers may find, that they're due to be deported. They're here illegally and they commit another crime, they ought to be deported. That's what the law says, and that's what we intend to do. And it's amazing to me that some of the mayors are so reluctant and so hostile to that simple request. And I don't think it's my duty to give out grants to cities who are failing in a most fundamental relationship between two federal-state jurisdictions.
Well, I don't mean to imply, General, that you're picking on New Orleans. I think the letter you sent to New Orleans, you sent a similar letter to New York City and I believe Philadelphia, if I'm not mistaken, and Chicago. And I mean, I think it's clear that our mayor in New Orleans does not agree with America's immigration laws. And I understand that. This is America. You can believe what you want. But my understanding is that we have to follow those laws. And my understanding as well is that all the Justice Department is asking is that the city of New Orleans follow federal law or go change it. Is that your understanding?
That's correct.
Okay.
In fact, we should really strengthen 1373. It's a common sense request for partnership with our state and locals that we support in any number of ways. I'd love to see our relationships continue to get even better than they have been nationwide. It's the key to crime fighting.
I want the record to reflect, Mr. Chairman, I stayed within my time.
Thank you very much.
Thank you, General.
Senator Whitehouse.
Thank you, Chairman. Welcome back, Attorney General Sessions. Just two opening questions. Over and over again in this committee and others, we have heard the intelligence and national security professionals of our country and people who study those issues professionally warn us that campaign and election interference by the Russians is not going away, that we can expect more of it in the 2018 election, that we can expect more of it in the 2020 election. What I would like to know from you is the name of a person in the Department of Justice whose job it is to look at that and make recommendations to the Senate as to what legislative remedies we should pursue to prevent that warned of activity from happening. Is there such a person, and what is his or her name?
Well, I think it would fall within our National Security Division, which is led by Dana Bente, who also was appointed U.S. Attorney by President Obama in Northern Virginia. But we need, I'll be frank, I don't know that we're doing a specific legislative review at this point.
Do you think it would be prudent to do
you make
review? We have been warned.
I take that as a suggestion, and I know that with your time in the Department of Justice, you could contribute to that discussion. So I'd be glad to discuss it with you.
Similarly, there is an executive order out of the White House regarding cybersecurity that is more or less a call for information from various cabinet departments. To my knowledge, there has been no proposed legislation of any kind. My conversations with Mr. Bossert at the White House have not produced any type of liaison or way of going forward on this issue. As you know, there are multiple congressional committees that touch on cybersecurity, and it really complicates life if there is not somebody at the Department of Justice whose job it is to work with us on cybersecurity legislation. And the silence has been deafening. If you could get me a name of a person whose responsibility is at the Department of Justice to work with the Senate on cybersecurity legislation, that I think would help move things forward.
I will do that, and because there are two levels of it. First, at any time, I hope that you would call our legislative affairs and say, I want to talk about legislation.
Well,
secondly,
the reason I have to bring this up with you here right now is that we have a lot of trouble getting answers to anything out of the Department of Justice. I've got a list here of unanswered mail January 30, 2017 letter, unanswered. February 17, 2017 letter, unanswered. March 7, 2017 letter, renewed September 15, 2017, unanswered. May 26, 2017 letter, unanswered, renewed July 27, 2017, unanswered. July 11, 2017 letter, renewed September 26 and October 17th, unanswered. September 26 letter, unanswered. So please don't refer me to the people who are supposed to be in charge of this relationship when they won't even answer my mail.
Well,
months and months and
my new director was just confirmed shortly. Recently, and we've cut the backlog by half, and we're going to continue to cut that backlog, and we'll get on that. But I guess another thing, knowing that you are particularly knowledgeable about these complex issues,
the cybersecurity
you would like,
issue.
yes, you would like to talk to an attorney who's actually working the cases and has dealt with the issues in more
Yeah, I've been over to see the FBI guys
legislative
who run that
affairs.
shop, and so yeah, I'm up to speed on that side. The issue is there are things we need to fix legislatively on cybersecurity, and at the moment, I can't find a point of entry into this administration of anybody who is working on cybersecurity legislation or is appointed to or delegated to. So that's the person that I need about legislation, not just an update on cases. I'm pretty familiar with that stuff. Okay?
I understand.
So, executive privilege. We talked about it a little bit. The reason I sent you the letter would be so that you'd be prepared to talk about executive privilege, and this wouldn't be a gotcha moment. But let me ask if the November 4th, 1982 executive order by President Reagan is still the guideline under which the department operates, or have you changed that guideline?
That is a part of the principles that we operate under, yes.
It is the document that describes how the executive branch will respond to executive privilege, correct?
Well, it's that and case law and other executive documents that have been issued over the years.
So here's what let me know if any of this has changed. That rule says that executive privilege will be asserted only in the most compelling circumstances and shall not be invoked without specific presidential authorization. Is that still the rule?
Repeat that.
Executive privilege will be asserted only in the most compelling circumstances and shall not be invoked without specific presidential authorization.
Executive privilege cannot be invoked except by the president.
Congressional requests for information shall be complied with as promptly and as fully as possible, unless it is determined that compliance raises a substantial question of executive privilege. Is that still the rule?
That's a good rule.
The Attorney General has the authority to determine on his own that executive privilege shall not be invoked. You can make the decision not to invoke executive privilege yourself.
Well, the Attorney General does not have the power to invoke it, period. Only the president can.
But you can determine that it shall not be invoked. You have the negative power to allow questions to be answered and documents to be released as not violating executive privilege. You can make that determination under paragraph 3, correct?
I'm not sure about that.
All right, well.
I don't think so.
Okay, I'm reading aloud. So the department head, the Attorney General, and the Council of the President may, in the exercise of their discretion in the circumstances, determine that executive privilege shall not be invoked and release the requested information. The Attorney General says it right there.
Well, I don't believe they can do it without the approval of the president.
They can't release information. Of course they have to be able to release information without the approval of the president. You do it all the time.
Well, I guess you're talking about core, but not about core privileges of the executive branch, such as private conversations between his top cabinet people.
Even for that, there's still this rule that the issue has to be presented to the president. You have a moment, what they call a request of the congressional body to hold this request for information in abeyance. You have a period of abeyance you're allowed to ask for under the executive order while you get the presidential determination if you're going to assert executive privilege. But sooner or later, the claim of executive privilege must be made with the specific approval of the president. And my concern is that this period of abeyance has turned into a non-assertion assertion of executive privilege. We have questions that we've asked you about going back to your Intelligence Committee appearance in June or July. I mean, how long a period of abeyance do you need to get the answer from the White House as to whether these questions are protected or not? You can't have a situation in which the president never has to assert it and the abeyance goes on indefinitely. Don't you agree with that?
Well, I think you make a point, but the burden is on those who want to breach a core privilege of the president, which is private conversations with his attorney general, to show precisely what it is that you'd like him to waive it on. And that's what your letter failed in. It was sort of reverse.
Okay.
It said you have to tell us what you're going to do, want to talk about, and
for the record,
what
Mr.
you're not
Chairman,
going to talk about. And I think it needs to be.
It was intended to refer to the questions as to which you had asserted a interim executive privilege.
Okay.
So we'll follow up on that, and we'll have more time.
Yeah. But I do
specific questions asked of you in the Intelligence Committee, and we'll pursue when I have more time.
And just briefly, I have to say that the executive branch is a co-equal branch, and you would not want someone demanding to know who you talk to in your office, your counsel, your chief of staff. Neither would we want to be prowling willy-nilly through the Supreme Court, what their clerks knew and what they were told by the justice as leading up to some decision that's not popular. So I would just urge us all to first and foremost respect the legitimacy of any president's right to seek advice in confidence. Eisenhower is once reported to have said, if one of my advisors reports the advice they gave me during the day, they'll be fired that night. I mean, this is not a little matter. That's all I'm saying to you. And if this isn't legitimate and you make the specific cases, we'll review it. But it shouldn't be done casually, I gotta say.
My time is up.
Before I call on Senator Graham, a question to you on this very subject. Has the Intelligence Committee, since you told them similar to what you're telling us today, attempted to compel you to either answer specific questions or claim privilege or subpoenaed you in any way to get answers to their questions?
I don't believe so, okay. Mr. Chairman.
Senator Graham.
Thank you. For the record, that was more than a little bit. Okay.
I thought it was important enough to both Senator Whitehouse and Senator Sessions to maybe that'll shorten it for other people that maybe want to have the same harangue.
It was important, but it wasn't a little bit. Okay. Speaking of letter,
I ought to be able to find a little bit.
I'm joking.
Oh, joking. Okay.
And I want my time back for joking. So
give him back his time.
Good. There we go. So, speaking of letters not answered. On August the 30th, Senator Grassley and I sent a letter over to the Department of Justice wanting information related to drafting of memos exonerating Secretary Clinton before the July statement of Director Comey, and we've got nothing back. Do you think we'll ever get an answer to that letter?
You need an answer or explaining why it can't be answered.
Well, either way. So the FBI.
I will take that and make sure it happens.
So apparently on the FBI's website, they've got emails with no content suggesting that Comey in May was talking, and the title of this thing is, what is the title of this thing? The email. Drafts of Director Comey's July 5th, 2016 statement regarding email server investigation. That's what the title of this thing is, but when you look at it, there's nothing there. So apparently in May, Comey was talking to senior staff about draft memorandum clearing Clinton before he ever talked to her. Are you aware of this?
Well, have not been engaged in that
well, who is
subject because I told the committee at confirmation.
But who did I talk to? Who did I talk to about getting my letter answered?
I think you should direct your letter to the Deputy Attorney General or to the Legislative Affairs.
And the reason we wrote that letter is because there's a Hatch Act investigation of the former FBI Director that the Committee Office of Special Counsel under the Hatch Act gave transcripts to the committee where two senior people talked about drafting this memo. So we just want to know, did Comey instruct his people to draft memos rendering a conclusion about the email investigation of former Secretary Clinton before July, before he interviewed her, not before July? So if you could have somebody answer that question, we would appreciate it.
We will
thank you.
Respond to your inquiry.
Thank you very much. Sentencing reform. There are many members of this body, this committee, are looking at trying to reform sentences for nonviolent offenders. Would you be willing to work with us in that endeavor?
I certainly would.
Okay. I know you want to secure the border. You talk the president's border plan. Count me in for securing the border. When you talk about a wall, is it a 2,200-mile wall?
No, I think the president made clear he doesn't expect that.
Do you know how long the wall will be?
I do not.
Okay, but it won't be 2,200 miles.
No, it will not.
Do you oppose?
Homeland Security, of course, is involved in that issue.
Do you support a pathway to citizenship for DREAM Act kids if we can get good border security in return?
I have not supported explicitly anything about citizenship, but I am prepared to say, and I think I've said previously, something could be worked out on this, but it can't just be one-sided.
Gotcha. I agree with that. I agree with that. Now, first thing I want to talk about is Russia. Did you ever hear of anybody in the Clinton campaign talking about having collaborated with the Russians?
You mean on the media or something?
Yeah, I mean, did anybody in the campaign, did you ever overhear a conversation between you and anybody on the campaign who talked about meeting with the Russians?
Oh, you said the Clinton campaign.
I'm sorry.
The election.
Trump campaign, I apologize.
I have not seen anything that would indicate a collusion with Russians to impact the campaign.
Were you aware of a meeting between Don Jr., Manafort, and Jared Kushner with a Russian lawyer and some other Russians in Trump Tower?
No.
Okay. Did they ever tell you about the content of that meeting?
I've never discussed the content of that meeting.
So no one's ever told you, hey, the Russians on our side, they want to help us?
No. And that all I know about is what's been in the papers.
Okay.
Which I haven't followed that closely.
As to the Clinton email investigation, do you know if there was a phone call between the former Attorney General, Ms. Lynch, and the White House regarding whether or not she should take a meeting with former President Clinton on the tarmac?
No.
Is there any way we could find that out? Or records of that, would there be records available?
That would be, the inquiry could be properly directed to the Deputy Attorney General.
Okay, I'll do that. Do you know if the so-called Trump dossier was ever used by the Justice Department to seek a warrant under FISA?
I have no idea.
Could you find out if that did happen?
I believe it would need to be directed to someone else in the department. But I think you could certainly make that inquiry, and you deserve a yes or no response.
Okay. Now, Secretary Comey gave 3 reasons at various times, and I can't find my sheet here, about why he jumped into this case in July. First, if that's the main reason the president wanted to fire him, his jumping into the email investigation and taking it over in an unprecedented way, which I agree with you, why did it take so long?
The investigation?
No, to fire him.
You mean why did the president?
The president knew when he was inaugurated that Comey jumped into the middle of the Clinton email investigation, took the job of the Attorney General over. That's the main reason that he was fired. Why did he wait so long to fire Comey?
Well, I'm not sure he ever grasped the full import of that. He asked the Deputy Attorney General Rosenstein and me for a recommendation, and that's the recommendation we gave him. It's something that everybody familiar with the Department of Justice had been buzzing about for months.
Now, this is very important. I got 9 seconds. I know that Comey has told other committees that the main reason he got involved in July to take over the investigation was not because of the tarmac meeting, was because he was worried there was an email in the hands of the Russians between the DNC and the Department of Justice. And I know that testimony exists. And some claim the email was fake. Do you know anything about this? And is there any way for us to find out what actually happened?
Without suggesting one way or the other that I know anything about it, I would just say that would be improper for me to share at this time if I knew.
Thank
you. Senator Klobuchar.
Thank you very much, Mr. Chairman. Welcome back, Attorney General. I'm going to start a few questions following up with some of my colleagues have been. The President has characterized the special counsel's investigation as a witch hunt. Do you share that view of the special counsel's work, and do you still have confidence in the special counsel as you stated before the Intelligence Committee in June?
Well, people are quite free in this country to express their views about matters of that kind. I'm just an old prosecutor who just says the process has to work its will.
Okay, but back in June, you said you had confidence in Special Counsel Mueller's work. Do you still have that confidence?
Well, I've known Special Counsel Mueller for many, many years before he became even FBI Director. So I think he will produce the work in a way he thinks is correct, and history will judge.
Okay. Are you still saying, has your testimony changed about Special Counsel Mueller since back in June?
No, I don't think, in my mind, hasn't changed.
Okay. When you appeared before the Intelligence Committee, you declined to answer questions as to whether you had discussed pardons for any of the people involved in the Russia investigation. Without getting into that or your reasoning, broadly speaking, do you believe that it would be problematic for an ongoing investigation if a president were to preemptively issue a pardon for someone who we have reason to believe is of interest to that investigation before the special counsel had a chance to finish his work?
Well, the pardon power is quite broad. I have not studied it. I don't know whether that would be appropriate or not, frankly.
So you don't know. So maybe we can follow up and you could look at that.
I would be pleased to respond to a written request.
So as you know, I'm very pleased with the choice of Christopher Wray, and I was there at his ceremony, and I also had a good working relationship with Director Comey. And do you believe there are inherent risks in any private communication between the President and the FBI Director? This comes out of the fact that Director Comey testified that he had 9 private conversations with President Trump in 4 months. He also testified that in 3 years he spoke only twice with President Obama. And following Director Comey's firing and his testimony that the President improperly raised the subject of an ongoing investigation during that private meeting, have you taken any steps to ensure that Justice Department officials are not being appropriately approached by the President or anyone in the White House? So the 2 questions are, do you think there are risks in this, and what steps have you taken?
Actually, we have discussed it at some length about the proper procedures. The Holder, I believe, Holder or Lynch memorandum on that subject remains in effect. It's probably tighter than previous memorandum on that subject, and the Deputy Attorney General and others in the department, I don't think we've completed our new policy, but we think there should be a careful policy on that subject. It's not appropriate, say, for White House officials to call lower level prosecutors or civil attorneys and carry on conversations. It should be done in an appropriate fashion. That's set out now. Those rules remain in effect, and we are reviewing whether they should be altered in any way.
Okay. Well, we'll look forward to that, and I'm sure you'll let us know if they're altered. On July 11th, I sent a letter with Senator Whitehouse and Ranking Member Feinstein. I'm switching now to some election issues. That was joined by my other Democratic colleagues asking about the Justice Department's apparent coordination with the Commission. This is the Pence-Kobach Election Integrity Commission, which you know has been controversial. We've sent a number of letters about this to try to figure out what the relationship with the Integrity Commission is between the Justice Department and that commission, because it is the Justice Department's job to ensure that voting rights are protected. And a number of us are really concerned about this commission that is requesting data from all over the country, including from Secretary of States, many of whom are Republican, who have objected to this kind of data going to a computer that is allegedly going to be housed in the White House. And I just wondered if you have had communications with members of the commission about their efforts and what kind of coordination is going on.
I don't believe I've ever had a single conversation with any member or staff of the commission directly.
And have people that worked for you been coordinating with them?
I don't know that coordinating is the correct what we've been asked for assistance on several issues. I think it's quite appropriate for the president to have a commission to review possible irregularities in elections. But you can be sure that the Department of Justice will fairly and objectively enforce the law.
That I believe that to be true. I'm just concerned that this commission is off doing their work, and we just found out that this week from the Washington Post that one of the employees has been charged with possession and distribution of child pornography. And so I just ask that you ask the Vice President and the Vice Chair, Chris Kobach, to answer our questions about that. If this staffer that's been charged with this horrendous crime had access to voter data, including data for minors, and what's the hiring process for this commission?
Well, we would fulfill our responsibility.
I just continue to be very concerned.
I think the direction should go to the commission.
Okay, they will.
Not
Thank you.
DOJ.
Thought maybe you could pass it on. So,
thank you.
Along the lines of elections, Senator Warner and I have been working on a bill that we think is really important, and this is more just to bring it to your attention. And I know you've recused yourself from the Russia investigation. I respect that decision. I truly do. And this is just beyond that, because it's about the ads that were bought during the 2016 campaign. As we know, 100,000 were bought on Facebook with rubles, but in all total, the estimates are that $1.4 billion was spent on political ads in 2016. And unlike ads that are broadcast on TV or radio or printed in the newspaper, there's no requirement on online platforms that they any point register those ads or have a way of indicating if they're paid for and how much money is spent on them. And it is it's a national security issue because of what we've seen now with Russia. But it is also completely absurd that we have some kinds of ads that you can register and check out and are a public file, and then these others are completely dark and hidden from view. And given what is going on, do you think that the election laws should be updated as overseeing the department that has jurisdiction over the people's voting rights to better protect our democracy?
Well, in this new fast-paced world with technology, perhaps there are needs to update it, and I would be pleased to work with you.
I appreciate that, Attorney General. Thank you very much.
Thank you.
Senator Cruz.
Thank you, Mr. Chairman. General Sessions, welcome back.
Thank you.
We miss you on this side of the dais. We've spent a lot of time in this hearing room together, and thank you for your good and honorable service as Attorney General and the many positive things that have happened at the Department of Justice in the last 9 months. I want to talk with you about an issue that is near and dear to your heart, which is immigration. And I want to cover a couple of areas. Let's start with DACA. I want to commend you. I want to commend the President for doing the right thing, terminating President Obama's illegal executive amnesty program. It was contrary to federal law. It was contrary to the President's responsibility under Article 2 of the Constitution to take care that the laws be faithfully executed. And it directed federal law enforcement officers to disregard binding federal law. So I commend you for announcing the suspension of that program. As you know, the President has indicated that it is now for Congress to legislate a program addressed to those DACA recipients. And there are right now considerable ongoing debates and discussions within Congress about how, if and whether to do so, and if so, how. My first question is, does the Department of Justice have a position on whether Congress should legislate a new amnesty program for DACA recipients?
The Department has not taken a position formally on that. The President has certainly left the door wide open and indicated that he would favor something like that, and it certainly would be a lawful and proper thing for Congress to do.
So my understanding is, as of September of 2017, there are 689,800 individuals currently with a DACA registration. There have been estimates done that there are nearly 2 million potentially eligible DACA recipients in the country. In your personal judgment, should those nearly 2 million people here illegally in this country be eligible for United States citizenship?
My best judgment that I've expressed over the years, that someone who enters the country unlawfully, if they're given some sort of legal status, a normal legal status, should not get everything that would flow to people who properly wait their time and enter lawfully. So I've not taken a position that that would support citizenship for those who've entered illegally.
Well, certainly as a senator on this side of the dais, I think you have multiple times spoken with great passion on the issue. As Attorney General, do you have any view on whether those here illegally should be eligible for U.S. citizenship?
Well, I haven't changed my view at this point.
Let me ask you, as Attorney General, if those some 2 million people here illegally that are potential DACA recipients were granted green cards and ultimately U.S. citizenship, do you have concerns about the next step of chain migration of those individuals then bringing in potentially 3, 4, 5 million relatives as the second step of an amnesty program?
Yes, that needs to be evaluated. And when you use the figure 2 million, it just raises the question that we should think carefully about, like who would qualify for a DACA program if one were to be carried out. And the President has made clear, and I think he cares about this, that he cares about young people who came here at a young age, but he also believes that the nation should have an immigration policy that serves the national interest, and that it should not be, it should be a more merit-based policy like Canada. And that's something I have believed in for a number of years.
So let me ask a different question. In your personal judgment, should those here illegally be made eligible for public welfare and for billions in both federal and state and local funds to provide for their various needs?
If people are here unlawfully, it strikes me as that the last thing you would want to do is subsidize that unlawfulness. And you should not be normally eligible for benefits. There may be some things we will do, no doubt about it, but still, fundamentally, a person should not be attracted to enter the country unlawfully and then demand lawful benefits.
Let me shift to a different topic under immigration, which is border security. I want to commend the administration. Early on, we saw dramatic decreases in illegal crossings in the neighborhood of a decrease of 2/3 in the opening months of the administration. I commend you for that. I will say I am concerned by reports I'm hearing from the border. I'm concerned, according to the public numbers in August of this year, Customs and Border Protection saw a 22% increase in apprehensions and inadmissible persons at ports of entry. I had a conversation recently with a rancher in South Texas who described to me how he said early in the year the number of illegal crossings had dropped significantly, but throughout this summer he's seen those numbers spiking up again, and he was very concerned, which is border security. I want to commend the administration. Early on, we saw dramatic decreases in illegal crossings in the neighborhood of a decrease of 2/3 in the opening months of the administration. I commend you for that. I will say I am concerned by reports I'm hearing from the border. I'm concerned, according to the public numbers in August of this year, Customs and Border Protection saw a 22% increase in apprehensions and inadmissible persons at ports of entry. I had a conversation recently with a rancher in South Texas who described to me how he said early in the year the number of illegal crossings had dropped significantly, but throughout this summer he's seen those numbers spiking up again, and he was very concerned that it was returning to levels that we saw earlier. Are you concerned about that, and what is the Department of Justice and the Department of Homeland Security doing to prevent that?
I'm very concerned about it. The president's own strong leadership resulted in a decline, we believe, of almost half of the attempted entries into the United States. Colleagues, if you make clear the border is closed and we back it up, there's no doubt the attempts to enter unlawfully will plummet. This is not an impossible task for America to secure the border. But, so they're challenging us now. There are many, many problems with our ability to enforce the law, some loopholes of monumental proportions, and I strongly believe that legislation from Congress is going to be essential for doing what the American people want. So a lawful system they can be proud of.
Let me ask one final question. I recently did a town hall with a number of Border Patrol agents and visited with a significant number of Border Patrol agents all along the Rio Grande. And what I'm hearing from the Border Patrol agents is that the policies of catch and release of the Obama administration are still continuing in the current administration. That is highly troubling. When I heard those reports in January and February, I told them, give the administration some time to get their team in place, to change policies. You can't turn a battleship overnight. It's now October. Is the Trump administration continuing the policy of catch and release? And if so, what is the plan to end that policy?
I'm glad you asked that question. In 2011, we had a backlog of immigration cases of 300,000. It's now over 600,000. 5,000 people in 2009 who were apprehended at the border claim they should not be deported because they have a fear of being sent back home. Last year, it increased from 5,000 to 94,000. And those people are basically entitled to hearings. And this is a loophole that's too big. And we need to create some sort of control over it. We're looking at if there are any things that we can do effectively short of legislation, but there's no doubt, Mr. Chairman, we need legislation on this subject and several others. We are adding judges. We've added, I think, 50 already. We'll have another 40 by January, and the backlog, instead of going up, will be going down. And we'll continue to work at that, but legislation is critical.
General, my time has expired, but if I could just ask for a direct yes or no on whether catch and release is still the policy.
Essentially, it's not the policy. It's just the reality that there are so many people claiming and being entitled to hearings that we don't have the ability to provide those hearings, and they're being released into the community, and they're not coming back for their hearings. It's still unacceptable.
Senator Franken.
Thank you, Mr. Chairman. Attorney General Sessions, welcome back. The last time we spoke, I asked you about Russian interference in the 2016 presidential election. There is now absolutely no question that the Russians meddled in the election in order to undermine confidence in American democracy, to damage the campaign of Hillary Clinton, and to boost Donald Trump. Our intelligence agencies have confirmed this. We also know that there were many contacts and communications between Russian operatives and Trump campaign officials and associates. Now, in order to make sure that this kind of attack never happens again, we need to understand what happened and whether anyone inside the Trump campaign assisted the Russian effort. During your confirmation hearing, I asked you, and I quote, if there is any evidence that anyone affiliated with the Trump campaign communicated with the Russian government in the course of this campaign, what will you do? That was a simple, straightforward question. What will you do? The implication was, will you recuse yourself? But rather than answer that question, you replied, quote, I have been called a surrogate at a time or two in that campaign, and I did not have communications with the Russians, close quote. That was on January 10th. On February 8th, you were confirmed, and on March 1st, the Washington Post published a story that you met with Sergei Kislyak, the Russian ambassador, twice during the campaign, once in July on the 18th and once on September 8th. And it was later reported that you met with the Russian ambassador a third time at the Mayflower Hotel in April of 2016. Confronted with these reports, you subtly changed your story. Your answer under oath before this committee was that you, quote, did not have communications with the Russians, period. But on the morning that the story broke, you said, quote, I have not met with any Russians at any time to discuss any political campaign. On Twitter, you said, quote, I never met with any Russian officials to discuss issues of the campaign. So, confronted with the truth, you started to qualify your answer. Later, in a letter you sent to this committee to clarify your testimony and to disclose 2 of your 3 meetings, you wrote, quote, I do not recall any discussions with the Russian ambassador or any other representative of the Russian government regarding the political campaign on these occasions or any other occasions. But this summer, the Washington Post reported that American intelligence agencies intercepted communications between the Russian ambassador and Moscow, in which he described 2 of his conversations with you. The April meeting at the Mayflower Hotel and the July meeting at the Republican National Convention. Citing both former and current U.S. officials, the intercepts reportedly indicate that you had, quote, substantive, unquote, discussions on policy matters important to Moscow. According to officials familiar with Russian intelligence reports, the ambassador was well known for accurately relaying his interactions with U.S. officials back to the Kremlin. Attorney General Sessions, in response to this report, the Justice Department declined to comment on the veracity of the intelligence intercepts, but DOJ did assert that you did, quote, not discuss interference in the election, which is also how you describe your communications to the Senate Intelligence Committee. So again, the goalpost has been moved. First it was, I did not have communications with Russians. which was not true. Then it was, I never met with any Russians to discuss any political campaign, which may or may not be true. Now it's, I did not discuss interference in the campaign, which further narrows your initial blanket denial about meeting with the Russians. Since you have qualified your denial to say that you did not, quote, discuss issues of the campaign with Russians, what, in your view, constitutes issues of the campaign?
Well, let me just say this without hesitation, that I conducted no improper discussions with Russians at any time regarding a campaign or any other item facing this country.
Okay, how do you know?
I want to say that first. And that's been the suggestion that you've raised and others, that it was somehow we had conversations that were improper.
May I suggest that...
No, you had a long time, Senator Franken. I'd like to respond.
Okay.
I think I have a...
Well, note that Senator Cruz went 2 minutes over, so I don't want... they're going to cut me off, and so I want to ask you some questions.
No, I don't, Mr. Chairman, I don't have to sit in here and listen to his...
You're the one who
charges
testified
without having a chance to respond. Give me a break.
Time he's taking right now, and I'll give you that at his time.
Okay, thank you. Go ahead. Take whatever
It was not a simple question, Senator Franken.
I'm sorry?
It was not a simple question. The lead-in to your question was very, very troubling, and I answered to you in a way that I felt was responsive to what you raised in your question. Let me read it to you. You said, CNN has just published a story, meaning that day, while we were in the hearing, that none of us had heard about.
Keep reading.
And I'm telling you this about this news story that's just been published. I'm not expecting you to know whether or not it's true, but CNN just published a story alleging that the intelligence community, that's of the United States of America, provided documents to the president-elect last week that included information that, quote, Russian operatives claim to have compromising personal and financial information about Mr. Trump. You went on to say these documents also allegedly say, quote, there was a continuing exchange of information during the campaign between Trump's surrogates and intermediaries for the Russian government. Now, again, I'm telling you this as it's coming out, so you know. But if it's true, it's obviously extremely serious. And if there's any evidence that anyone affiliated with the Trump campaign communicated with the Russian government in the course of this campaign, what will you do? So, taken aback by this dramatic statement that I'd never heard before, between Trump knew nothing about, I responded this way. Senator Franken, I'm not aware of those activities. I have been called a surrogate a time or two in this campaign, and I did not have communications with the Russians, and I'm unable to comment on it. I don't think that can fairly be interpreted as saying I never had conversations with any Russians. It was referring directly to the suggestion that there was a continuing exchange of information between Trump surrogates and intermediaries for the Russian government, which did not happen, at least not to my knowledge, and not with me. And that's why I responded the way I do. And I'm disappointed. Yes, you can say what you want to about the accuracy of it, but I think it was a good faith response to a dramatic event at the time. And I don't think it's fair for you to suggest otherwise.
Okay, if I give you an additional 3 minutes and then finish.
He took more than 3 minutes.
No, he didn't.
Yeah.
He took about 2.5. Well, go.
No.
How much do you want? I don't want to take a lot of time bargaining with you.
Well, I didn't take as much time as Senator Franken took.
Hey, let me just deal with Senator Franken. 3 more minutes, please.
Okay, first of all, you said I did not have communications with the Russians. This was about ongoing communications. You had 3 communications with Kislyak. And now you can't recall, with answering Senator Leahy, you can't recall whether you discussed what you discussed with Kislyak.
What I would say to you is,
please.
Okay, go ahead. You go make a lot of allegations, Senator. It's hard for me to respond to them in the time I've got.
Can I have a little bit more time? Okay. You said today in response to Senator Leahy that you don't recall whether you talked about the campaign, whether you don't recall whether you talked about issues and Trump's views on issues with Russia. Those are very, very relevant to the campaign, whether a surrogate from the campaign is talking with the Russian ambassador about the candidate's views on Russian policy, especially at the Republican National Convention, at the Mayflower Hotel the day before Trump is going to give his maiden speech on foreign policy. That's very different. Not being able to recall what you discussed with him is very different than saying, I have not had communications with the Russians. The ambassador from Russia is Russian. And how your responses morphed from I did not have communications with the Russians to I did not discuss substantive I did not discuss the political campaign, and then finally going to I did not discuss interference in the election. That to me is moving the goalpost every time. And we're starting off with an extra point, and by the end we're going to a 75-yard field goal. If it has to be us, saying I didn't discuss interfering with the election is your last statement, that's a very different bar than I can tell you I did not meet with any Russians.
Relatively short answer.
So he gets to do about 10 minutes improperly framing this subject, and I'm given a short chance to respond?
Proceed, please. But then we're going to call on Senator
First and foremost, Senator Franken, you and I have had a good relationship on this committee. I would tell my colleagues, I think most of you know, I've committed myself to a high level of public service, to reach the highest standards of ethics and decency in my service, to be honest about things that I say. And so you have now gone through this long talk that I believe is totally unfair to me. It all arose from this question. When it was charged that these documents allegedly say, quote, there was a continuing exchange of information during the campaign between Trump's surrogates, as if all of them, Trump's surrogates and intermediaries for the Russian government. Isn't that what you said? You're shaking your head.
No, don't Trump's surrogates.
It said Trump's surrogates. Didn't say some of. Said his surrogates. And I felt a need to respond. And I responded on the spot. We've been 6 hours in the hearing, the end of the day, and I said, I'm not aware of those activities. And I wasn't, and am not. I don't believe they occurred. I said, I have been called a surrogate a time or two in that campaign, and I did not have communications with the Russians. I'm unable to comment on it. I was talking about it as a surrogate in the campaign. I didn't have a continuing exchange of information. So now everything else, so now you take that to say if I ever met with a Russian, I've not been candid with the committee, and I reject that.
Senator Sass.
General, thanks for being here. There was some drama there. Sorry to have added to the drama and distracted you for a minute. I was paying enough attention there that I dumped a Dr. Pepper on Senator Cruz, so that's what was distracting us on this side of the dais. I would like to continue talking about the Russians, but in the context of the long-term objectives that Vladimir Putin has to undermine American institutions and the public trust. Obviously, the 2016 election matters a lot, and there are multiple ongoing investigations about that. I'm trying to talk about something slightly different. The longer-term goal that they have, because anybody who reads intelligence, this isn't through the prism of who you voted for in the 2016 election or what you think happened in the 2016 election, as important as all of that is. Anybody who reads intelligence knows that we face a sophisticated, long-term effort by a foreign adversary to undermine our foreign policy and our ability to lead in the world by trying to undermine confidence in American institutions. There's nobody who's reading intelligence right now that doesn't know that Vladimir Putin has that objective. So this shouldn't be this part shouldn't be a Republican versus Democratic issue. Vladimir Putin is an opportunist, which means that any partisan or ideological alignment he has is temporary. He wants to undermine America. And every patriotic American ought to be concerned about that. You listen to certain news outlets, and it sounds like there's a Russian behind everything that's happening in America, and it's laughable. But you listen to other news outlets, and it's seemingly the case that Vladimir Putin is somebody that we should trust, and he has America's best interests at heart, which is more absurd. So I think we know, again, people who are reading intelligence know that Russia's going to be back in 2018. They're going to be back in 2020. And they have goals to undermine American, Democratic, Republican, small r, small d institutions, and to undermine our confidence in these institutions and to exacerbate American-on-American hatred. We live at a time where info ops and propaganda and misinformation are a far more cost-effective way for people to try to weaken the United States of America than by thinking they can outspend us at a military level, though we're underinvesting in a lot of military hardware and long-term planning. So as the nation's chief law enforcement officer and as a supervisor of multiple components of our intelligence community, I'm curious about your views on this issue, and I want to ask you a series of questions. The first is, do you think we're doing enough to prepare for future interference by Russia and other foreign adversaries in the information space?
Probably not. We're not. And the matter is so complex that for most of us, we're not able to fully grasp the technical dangers that are out there. We have commercial penetration by some of our toughest trading partners. We've got disruption and interference, it appears, by Russians, officials or people, and it requires a real review.
And so, under your leadership, what concrete steps has the department taken or should the department take to learn the lessons of 2016 for the purposes of fighting against future foreign election interference?
Well, we are looking at a number of things. We're specifically intensely reviewing the commercial interference and theft of trade secrets and important data or information that some private companies have spent decades developing in hundreds of millions of dollars and have it stolen in a moment. And we've got indictments that deal with some of those issues. The National Security Division of the Department of Justice has got some really talented people. The FBI has as good a group of experts on sophisticated computer technology as probably exists in the world. But whether we're at the level we need to be yet, I don't think so.
So let's distinguish between two things there in your answer. The first is, I think you were asked earlier if you have confidence in the January 6th, 2017 intelligence community assessment of Russian attempts to interfere in the 2016 election? I had stepped out for a minute, but you agree?
I've never denied. I acknowledge that at my confirmation. Yes.
So you have no reason.
I have no reason to deny that or doubt that.
You have confidence in the integrity and the professionalism of the men and women of the intelligence community?
Yes.
There may be an issue, though, about whether or not our pipeline is robust enough. Do we have enough people coming into the National Security Division? If you were arriving at DOJ today as the Attorney General and you were going to focus on NSD for the first 100 days you're there, talk us through a little bit about how you would prioritize in that space, because my view is that we're investing way too little in the pipeline to be ready for offensive and defensive aspects of cyber writ large, but especially info ops and misinformation campaigns.
Well, the misinformation campaign is something that I'm not sure we're at the bottom of yet, and it needs to continue to be examined. When I was on the Armed Services Committee, I got legislation passed to review our entire Defense Department situation to see how vulnerable we are there. And we have many vulnerabilities in our Defense Department, in our missile systems, perhaps. And then we've got the commercial penetration that we have some cases that ongoing now that validate that concern quite clearly.
So that's looking chiefly at current hardware and software exposures and retrospectively. But do you think the Department of Justice has a proactive role in looking at hardening our democratic process for foreign interference?
You make a valuable point. If you have any legislation or thoughts on that, I would be glad to hear it. And I'm not sure we have a specific review underway at this point in time. Of course, most of this has to be coordinated with the intelligence community, NSA, CIA, the Director of National Intelligence.
Well, I appreciate your responsiveness to me on a number of other issues, so I will follow up with you in a less public forum about that. I'm nearly at time, and I won't ask for precedent of the 13 minutes and 20 seconds, Mr. Chairman, of the questioning that preceded me. But if I can run over by 30 seconds, I would like to just draw to your attention, General, the fact that we have a number of crimes committed by illegal aliens in Nebraska. Some of these are some of the most heartrending crimes you can imagine. But I want to point out that this isn't just a case of cherry-picking particular isolated bad apples. We know that some of the crimes that we're dealing with